Seated. We're here. Matter of Badilos et al. Versus Karen, friend. Versus Medical Specialties Inc. PC et al. For the record, they were identifying themselves and who they're representing.
I'm Robert Anderson. I'm here for Franciscan Alliance.
Alyssa Stanitakis from Medical Specialists.
Okay.
And Robert Johnford on behalf of the plaintiffs' doctors.
And we're here on
Jonathan Hall for all plaintiffs, Your Honor.
Good afternoon, Your Honor. Harold Abraham on behalf of the plaintiffs.
and we're here on an emergency motion to compel discovery. Is that what?
Well,
I think it's mushroomed, unfortunately.
Motion to enforce discovery. Is that what it is?
an expedited.
Expedited discovery.
Yes. And it's. I think at this point, Washington did multiple different things with this motions filed since that motion, and several other issues have come up from a procedural standpoint, from a calendar and ability to get things done in a timely fashion.
Well, that's what we're looking at this. I mean, how many doctors do you have here?
A lot. Your Honor, in the emergency motion for leave to conduct expedited discovery, we have 12 people, one of whose deposition has been taken thus far.
Okay.
That was Dr. Don Dumont, whose deposition was taken at my office last week. We have currently set for tomorrow morning at 9 a.m. Dr. Stemmer, Dr. Alexander Stemmer, one of the principals of Medical Specialists Inc. PC. We also have, in addition to what's listed in paragraph 2 of our motion, we have noticed Mr. Attorney Anderson with a 30B6 deposition notice for a knowledgeable person regarding these transactions with Franciscan, not medical specialists. We have asked for the deposition of Jackie McLean, who provided an affidavit which is attached to the motion for preliminary injunction. Sharon Catania, same issue. There's an affidavit of Ms. Catania. And there's a Dr. Ricardo Pizada, who was listed as one of the people who medical specialists sought to employ after the asset purchase agreement was finalized. And Your Honor, some of this came up, quite frankly, during the deposition of Dr. Don Dumont. I believe it was the opinion of opposing counsel. They felt that our questions were going further afield than what we needed to defend ourselves against the motion for preliminary injunction, and wanted us to only ask questions in limited areas, and thought that it might be best for the court to decide what those areas would be. I'm in the position of having my opponent craft my battle plan, which I'm really willing to take a pass on. The problems with going forward with a preliminary injunction, if we don't have the ample opportunity to prepare everything we need to prepare, and oppose who we feel we need to oppose, not who the movements feel we need to oppose, is that the potential entry of a preliminary injunction carries with it extreme harm to my clients. It would have the effect of at least temporarily shutting down their medical practices. They've got 4 doctors, their families, and thousands of patients, and staff members for that matter. And we think to go into a hearing like that, where we can defend ourselves against this preliminary injunction, half-cocked, for lack of a better way to put it, because we haven't been able to thoroughly conduct the discovery that we want to conduct, because of the compressed dates, is really unfair to our clients. And I want to point out to the court as well that the ruling on our motion for summary judgment in this case, which was denied by the court, came out, I believe it was July 17th. I think the court signed it on the 16th. I think it shows up in the docket that day. We got it on the 17th or 18th. The physicians that I represent had resigned from medical specialists and began working July 1st, openly and without any, trying to hide that they're working in the area. I mean, they're at the hospitals, and all the other doctors see them, and we're not trying to, fly under the radar. Given that, The motion for preliminary injunction was filed about a month later, I think at the very beginning of August. So the doctors worked for a month without having to run, and all of a sudden we need a preliminary injunction and we need to set the hearing 3 weeks from today, even though we have some pretty voluminous discovery. Quite frankly, I think we can get it done, but I can't get it done between tomorrow morning at Dr. Steiner's deposition and Monday morning we're going to be here for a full hearing. I also received today two motions to quash the depositions of 3 witnesses, or the subpoenas, the subpoenas for 3 witnesses to appear at that trial. One of them deals with, I believe there's going to be a doctor who's going to be out of town, and I believe there are at least 2 of the 3 that want to have a specific time to be here because they have patient obligations too. I don't know how to provide them with a specific time when they would have to be here on that day, because I don't know how long the movement case is going to take for them. How many witnesses they intend to call. But I do intend to have the ability to defend my clients and to eliminate this issue, but I can't do that without the ability to conduct at least, am I going to ask every witness every question I want to ask them in this entire litigation? No. But I think Dr. Dumont's deposition went up to about 4 hours. And there are some doctors who were not shareholders of medical specialists in PC that I would not have to question for nearly that long, maybe an hour at the outside. The doctors that they claim became employees since the asset sale, which they claim gives them a protectable interest in order to keep my doctors from working in this area. I'm sorry, not my doctors, the plaintiffs from working in this area. So, without the ability to conduct that discovery how I see fit, as opposed to the questions they want me to ask because they want me to be limited, I don't think I can do that. We have another issue regarding the Franciscan defendant. We had asked Mr. Anderson, counsel for Franciscan, a little while ago, about a week or so, if Franciscan was joining in the motion. Because I think that changes the landscape of this somewhat, and it changes how we're going to defend ourselves. Mr. Anderson doesn't have a time frame to answer that request, but I don't have an answer to that. I don't know if Franciscan is going to be a participant in this endeavor or not. It's just medical questions.
Which motion are you referring to?
Your Honor, we simply asked Mr. Anderson via an email request whether or not Franciscan was going to participate. That's the motion for preliminary injunction.
Okay.
That would be set for the 19th. That is a week from today. Your Honor, I would ask that the court not limit us in the questions we can ask. That if the court wants to put a time frame on the depositions, that a reasonable time frame can be allowed, but I don't want to be limited on the areas that I can go into. And I don't think that between now and next Monday I can line this up. I don't think there's some emergency that is sought to be foreclosed upon. I think what we're talking about is doctors who were practicing for a month in their new practice before anything was done. We're talking about a couple of additional weeks so that we don't have to compress this into a mess. Obviously, there will be more things that may have to be done before a final if that becomes necessary in this case. But the preliminary could have such far-reaching impacts, not just on my clients, but on the general public. There are thousands of patients of the general public, that it could be very harmful to them, and we have to come in with everything we need or that we think we need to defend ourselves against that potential issuance of a preliminary injunction. There's also some other issues. The preliminary injunction is, I think, set to begin at 10 o'clock on the 19th and go for the balance of that day. I have a substantial feeling that it can't be done at that time, now, in that time frame. I know this court, because I've been here on another injunction case, and Mr. Jensen, in fact, and I were on the same side of that case. I think the court was here until about 6:30 or 7 o'clock that night doing that. I hate to do that if we can find the time within the next couple of weeks to say, now you've got the time to get your discovery done. Here's a couple of weeks. I'm going to let you have X hours per component. Okay? And you should have no problem getting this ready in time. One deponent, actually, Your Honor, is in Maryland. And she's someone that we absolutely have to question because it goes to, among other factual issues, it goes to a credibility issue. It's Dr. Suyin Chi, who Dr. Stemmer had stated in his affidavit was an employee, had become an employee of medical specialists. And now we're informed that Dr. Suyin Chi actually doesn't become an employee until October 1st. doesn't live here, and we found out is also currently not licensed to practice medicine, not just here but anywhere. So that's a myriad of issues when you're saying we have protectable interest because we hired this doctor. That doctor doesn't start working, or contract doesn't start until October 1st. I'm not sure that's a typo. I think that's something I need to get into. If I have to go to Maryland to do it, I'll go to Maryland to do it. We contacted a Maryland law firm, and then issued a subpoena, and we filed that here so that we can get our hands on that deposition, on that testimony. So I would suggest, at a minimum, that if the court wants to set parameters for the conducting of the discovery, that it absolutely be allowed to do so, and it can, of course, but that it be reasonable, and that anything less probably than 2 weeks from this coming Monday, from the 19th, which would put us into very early September, would just probably be too compressed to get it done. And in the interim, no one's going to be hurt, no one's going to die, no one's going to get sicker because we're practicing medicine. The alternative is not true. So I think we really need to go that route. I know there are some other issues on some other pending matters, but those are the ones I think that are key for today. I think they really all fall under our motion for the expedited discovery, which we made earlier. And we had actually served a written discovery, both document requests and interrogatories, on August 5th. And we asked the court that those be answered in 10 days from the date we filed them. Well, that 10 days is Thursday. I don't know if that can be done either. But those are the issues that we have. I'm sorry, Your Honor. And we also would request that the court order Franciscan to let us know whether they're going to be joining in the motion by a date certain, maybe 10 days in advance of the setting of the hearing or something like that. Because we don't, right now, we're not sure who we're fighting against other than medical specialists in DC. Thank you, Your Honor.
Good afternoon. I think at the outset we need to, obviously as the court knows, we're entitled to a prompt hearing on our preliminary determination. But in order to get to where we are today, I think we need, in all fairness, to go backwards to the filing of the plaintiff's complaint for declaratory determination, which was 10 months ago, Your Honor. And as we set forth in our response in the motion, our response in opposition to their motion to conduct the expedited discovery, we hadn't received a motion to continue the setting as the time filed, but I think the rationale of this response applies. 10 months, and there wasn't a single document request, a single interrogatory, or a single request for a deposition. Now, in response, they would say, well, we didn't know about the additional employment relationships that you have with Dr. G, and we didn't know about the agreement that you entered into with Franciscan that entitled you to employ these additional positions. That was all disclosed in response, in our response to their motion for summary judgment, which was back in May. And even after that, we didn't receive any discovery, not a single request for a deposition, nothing. Then we get to the point where we file our motion for preliminary determination. And yes, there had been some time that had gone by, but this is obviously a serious motion, and we take it seriously. We didn't want to file it without having a good faith belief that these physicians were violating, we believe, or were practicing, we believe, in violation of their restrictive covenants. So we did wait to get that information. And in addition, we were having conversations about whether we could resolve this issue without having to go forward with a hearing, and that took up another 4 or 5 days or so. So we did act as promptly as we felt we could, given the information that we had, and given the fact that we also were trying to work things out. And now what we're told is, well, let me back up. We get the motion for the expedited discovery. A day later, I have Dr. Dumont ready to be deposed in their office. And Mr. Reed keeps talking about how he doesn't want me to dictate his game plan. I wasn't dictating anything. I was just referring back to the arguments that they made, the reasons that they set forth for requiring expedited discovery was to find out about the relationships that medical specialists has with physicians who might be employed with it, and also to find out about the license agreement and waiver. And again, I go back to the fact that these were fully disclosed back in May, so I thought even then that this was rushed and a little bit late. But I made every effort to go ahead and give them what they needed, what they said they needed for this hearing. I had Dr. Dumont ready to go, And you're right, and Mr. Reed's right. That deposition lasted close to 4 hours, and I can tell you it went far beyond the areas that they delineated in their own motion to this court as a reason why they needed this expedited discovery. And I knew that with 10 depositions that we're trying to schedule, we weren't going to be able to get this done in time. The issues that they went into with Dr. Dumont had to deal with medical specialist organizational structure. It had to deal with the negotiations surrounding the asset purchase agreement. It had to do with whether the assets had been distributed yet. None of these issues apply to the physician employment relationship with medical specialists, and none of them had to deal with the license agreement and waiver. My guess is that that portion of the deposition was probably about 45 minutes. So, in all fairness, they should have had to stick to the arguments that they represented to this court as to why they needed these depositions. Even at that time, I had 2 additional depositions scheduled for Friday, Dr. Kukrasia and Dr. Stokar, who is the witness who, by the way, is going out of town. And I told them in advance, Dr. Stokar is going out of town. So this is your opportunity. We had Denise Weaver, another deponent, scheduled for tomorrow. But as a practical matter, we couldn't produce all of these witnesses for 3-hour depositions. They chose to not depose these witnesses. I wasn't saying this was going to be your only shot at them. All I was saying is you made certain representations, both to the court and to the parties, as to why you needed to conduct this discovery. If you stick with those representations, we can get all this done. We can get it done in advance of the hearing. And we are entitled to a prompt hearing. And the argument that I make in the response, which is I'm not surprised they're requesting this continuance. I think that this was the game plan all along. I think if they actually wanted to conduct the discovery that they said they needed to conduct, we clearly could have gotten this all done. With respect to Dr. Chi, they have noticed her deposition for the 15th, I believe. I spoke with Dr. Chi this morning. She's available, and we can go ahead with that deposition. So there really is no good faith basis to continue the hearing, given how much time has elapsed from the filing of the declaratory complaint in the first instance until today.
I might respond to a couple of those arguments. We say we want to go back to the filing of the complaint and take a history lesson on the case. That was 10 months ago. There were not depth interrogatories asked because we had felt very strongly that it was a case that would be right for summary judgment because it was mostly document sensitive. Since that time, we have found out that medical specialists tried to, for lack of a better way to put it, put Humpty Dumpty back together again and create a medical specialist that had a protectable interest after October 1st when they sold all its assets. We did not know that had occurred or any of those people had been hired until we got the response to our motion for summary judgment, which incidentally, when we filed our motion for summary judgment, the defendants had asked for more time to file their response so that they could conduct discovery of my clients, take their depositions. Didn't have to ask the court for it. I said, of course, you can have more time. I will produce my witnesses, and you can ask them whatever you want to ask them, and then you can file your response to summary judgment. Not a problem. It sounds like that only goes one way, which is okay. Everybody's entitled to handle their case the way they want to handle their case. But if we're going to go back to the beginning, that's going to be a little history. The court didn't know that it should know. In addition, the motion that we made to the court to conduct the emergency discovery does not limit, I don't think, by any operation of any law or case that I've ever seen, what I can ask at the moment at a deposition. I gave the highlights. Here are some of the reasons why I need it. I don't think I said these are the only reasons, and I swear I won't ask you no more questions. To say that by the filing of a motion to conduct expedited discovery, I've limited myself to my line of questioning, that's a new one on me. I think I'm entitled to ask these witnesses what I want to ask them. I think I'm entitled to the right amount of time to prepare, given the circumstances, and given the potential harm in this case of a preliminary injunction. I think it's only fair and just to be reasonable in what time can be allotted, and maybe to have a hearing date that maybe isn't. I just don't think, even if we do, and we may well be able to, submit substantial testimony in the preliminary injunction case by deposition without having to recall people and regurgitate what they already said. The court sits in judgment in this case. This is an equity, and the court can have those depositions and review them without having to have the person sit here and answer the same questions 2 times. So that's also something that may streamline the process. But I still think it's going to take more than 1 day of the court's time. I know it's only a preliminary. A final in this case, to flesh everything out, is a week, or probably at least 5 final days. This is at least a day and a half, maybe 2. Thank you.
Anything else?
No.
All right, how many witnesses are there now? So, you need to depose.
How many witnesses do
There
there?
there are 12, and we've taken one of the 12 depositions.
And you're going to depose all of them
Yes, sir.
for the preliminary injunction hearing?
Yes, Your Honor. I think we can, as to some of those, we can submit their deposition testimony without having to have them here live, which would streamline that process to a great deal. But in other words, that some of the witnesses that have become employees since the asset purchase won't have nearly as much to say because they just got it.
And these are all fact witnesses also, correct?
Yes, sir.
I think they're entitled to depose them. Let's see what kind of date I can get you in here real fast, real quick. You need a day and a half, you think?
I think that's...
You agree with that, Ms. Town? Take a day?
I think we could get it done in a day. I think a lot of these witnesses are entirely cumulative, but it doesn't hurt to have more time.
Okay.
Tell the girls I'm coming.
If you need about a day and a half, a couple of weeks out.
Like, get it back in.
September 4 and 5, the Wednesday and the Thursday.
September 4th and 5th.
We've got 2 other hearings on the 5th. One is the Compel board here at 11:30. I'm sorry, 11.
We should go the week before.
Oh, and Your Honor, Mr. Abrahamson informed me I want him to be involved. I'm sorry, was that a company? That's Jewish New Year. Is that September 4th and 5th?
Okay.
The week before, we did 27, 28.
To maybe start the evening of the 5th. It's a Wednesday? Is the
I
5th a Wednesday?
It's a Thursday. The 4th is a Wednesday, the 5th is a Thursday.
I'm sorry, did you say 27th, 28th of August?
And the 29th is open either.
Does all look good?
Your Honor, Mr. Abrahamson informed me that's okay. We can make other arrangements on that. The 4th and 5th.
4th and 5th.
That's
Okay. 9 a.m. Commence at 9 a.m. on the 4th. Anything else?
Your Honor, could I ask the court to provide a date that we can get responses, because it's less than 30 days, to our interrogatories and requests for production? At the end of this week or first part of next week or something like that?
How much time do you think you'll need to get a response to the written discovery?
Have it done by the end of this week easily.
Okay. What about an answer from Franciscan as to whether they're going to be participating in
Your
the...
Honor, that's oversight on my part, and Franciscan is not going to be joining in the motion.
So you have your answer today.
Thank you.
Okay. Anything else?
No, thank you.
Thank you.
All rise.